Well, welcome to Landmark Law. My name is Winnie Luck-Taylor, founder and principal lawyer of Landmark Law Professional Corporation in Markham, Ontario, Canada. Landmark Law provides quality, affordable, professional legal services in wills and estates, corporate law, and real estate law. And as part of our Wills and Estates webinar series, we're pleased to present on jointly owned assets. Before we begin, please read our disclaimer. The contents of this presentation is for information purposes only and does not provide legal advice or create a lawyer-client relationship with the viewer. So jointly owned assets, okay? An estate represents everything that you own. Okay? That's all your belongings that you own. Okay? However, jointly owned assets represent a estate that you own with someone else, okay? That you own with someone else in the capacity as joint owners, okay? Joint owners. So what does this mean? A really good example would be home ownership by a married couple. A lot of married couples, when they buy a home and both of their names are on the ownership documents, also known as a deed or a transfer in Ontario, the transfer will say on it, joint tenants, okay? Whereas if you have a couple of investors who own a property, most often the status or capacity of these investors as owners will say co-tenants 50-50 or co-tenants 40-60 or whatever the investors have decided would be the split or in ownership interests. Okay, so the difference between joint tenants and co-tenants would be the concept of a percentage ownership. Joint tenants, there's no concept of percentage ownership. So in a married couple, it doesn't say 50-50 on the transfer. It just says joint tenant. Well, what's the significance of that? Well, when there's no concept of numbers, that means that when one of these spouses passes away, the surviving spouse owns the entire property in its entirety, okay? The remaining spouse owns it in its entirety. This is due to the law of survivorship, okay? So jointly owned assets have this concept called the law of survivorship, okay? Whereas in the example with the investors, if one investor were to pass away, then the surviving investor wouldn't own everything, not by any law, not as a matter of law. The surviving owner wouldn't just own everything. Well, for the investor who passed away, we would look at the deceased investor's will and see who that deceased investor wanted to give his or her estate to. So for investors, the percentage that belonged to the deceased investor would pass according to the will. Okay? It doesn't go. And this is because if you're an investor, you own something, you're likely to want to give it to someone you love. It's highly likely that you love your family more than you like your co-investor. Your co-investor is a business partner, and your family is your family, your blood. Okay, that's usually what happens. Okay, but when we're dealing with joint tenants, these often are family members. Okay, and in our case, our example, a married couple, so they have decided that the survivor would own everything. It wouldn't pass according to the deceased spouse's will. Okay, so that's the key difference. Basically, we're not looking at a will when something is jointly owned. We're not looking at a will. The law of survivorship says the surviving owner will own it. And just as a matter of formality, the surviving joint owner would just have to go to the law office to update that deed or transfer to say that it's no longer in joint tenants, it's a single owner, right? That's just a formality thing. Okay. So because the property would, under a joint ownership, would pass according to the law of survivorship, it is not forming part of the deceased spouse's estate, right? It's not going under the will. It's not going under the will. It's not forming the estate. And when the trustee goes to file the will belonging to the deceased, the trustee does not have to calculate the value of the house because it's no longer owned by the deceased. It passed already under the law of survivorship to the spouse. So if the estate were to put down the value of the property, it would put down 0 because it doesn't own it. Okay? It's in the name of the joint owner by the law of survivorship. Contrast it with the two investors. If one of the investors passed away, then the trustee of the deceased investor would have to put 50% of that home in the probate application because the investor owned it as co-tenants, not joint tenants, and put down and specified percentages on the deed or the transfer, specified percentages, and that percentage is what gets calculated as part of the estate and is what passes to the beneficiary. And because it forms part of the estate and gets calculated, it is subject to estate administration tax. Whereas I don't like how I explain this. Too confusing. Let's start over. Welcome to Landmark Law. My name is Winnie Luck Taylor, founder and principal lawyer of Landmark Law Professional Corporation in Markham, Ontario. Landmark Law provides quality, affordable legal services in wills and estates, corporate law, and real estate. And we're pleased to present, as part of our Wills and Estates webinar series, the topic of joint assets. Before we begin, please read the following disclaimer. The contents of this presentation is for information purposes only and does not provide legal advice or create a lawyer-client relationship with the viewer. Jointly owned assets. What are they? Well, first of all, let's define estate. Estate represents everything that a person owns, okay? Everything that a person owns alone, okay? So let me explain. Jointly owned assets are assets that you own jointly with somebody else. A common example would be a home that is owned jointly between a married couple. Okay, so if I'm married, I would own, or I may own, a home jointly with my spouse. Jointly, okay? And the capacity or the ownership type on title is very important. On the actual ownership document, also known as a transfer or deed in Ontario, that document would say my name, my spouse's name, and it would say joint tenants. So the ownership capacity or status has to say the word joint tenant, okay, or joint ownership or joint account holder. Okay. Contrast this with owning something with somebody, but not as a joint owner, but as a co-owner, What's a common example? Two investors who own a property together, two investors. And on the deed or transfer of that real estate ownership, it will say the names of investor one, investor two, and often will say co-tenant, and it would have a percentage split depending on what the two investors agreed on. Yeah, let's use 50-50 as a typical example. And likely because they're friends or they're business partners, and that's what they contributed to buy this real estate property. Okay, so let me tell you what happens when one of these owners die in each of these scenarios. I'll go backwards. Let's look at the case of the investors. If one of these investors, say investor A, passes away, and investors A co-tenant portion was 50%, that 50% would now belong to the person who is named as a beneficiary in investor A's will, okay? So that is typically the case. There could be other agreements, business agreements between the two investors where investor B has to buy the 50% off of investor A's estate. Okay, that could be a scenario, but generally it passes it doesn't pass automatically to investor B. That 50% is owned by the estate, okay? And then it is processed according to what the will says or according to what some other business agreement between the two have. But this 50%, it was owned by the living investor A, and now it's owned by the estate of investor A. It still belongs to the investor A line, okay? Now let's go back to the married couple and the joint ownership assets. If spouse A were to pass away, okay, and their ownership status was joint tenants or they were joint owners, and it said that on the document, when joint owner spouse A passes away, it will pass under the law of survivorship to the surviving joint owner spouse B. It passes to spouse B. So, and remember, for joint ownership, there was never a concept of percentage split. Nowhere on the transfer or deed did it say spouse A has 50, spouse B has 50. There's no concept of percentage split. So when spouse A was alive, yes, spouse A had a joint, I guess you can say, interest in the home, but didn't have any percentage. It was always just called, a joint ownership. And when spouse A passed away, law of survivorship gives it to spouse B, who is surviving, and spouse A's estate, okay, estate meaning everything you own, does not own it, okay? This house does not no longer belongs to the spouse A, I guess, list of estate or a line, because law of survivorship says that spouse B gets it all, okay? So what's the advantage of this? We go to the investor's example. So now that we have explained that when investor A passed away, that 50% portion that was labeled on the deed or trust belonging to investor A now belongs to investors A's estate, and it will flow according to what the will says or according to what other business contract the business partners have. Okay, because it forms according to the estate, so it's always the estate, and then it gets handled by whatever means. Because it forms part of the estate, then when the trustee for investor A goes to file investor A's will with the probate office, fills out the probate application, the probate application will ask for the value of investor A's estate, and in the value of investor A's estate, we will include 50% of investor A's, that co-owned real estate, okay, that investment property, 50% of it. And we will have to calculate the estate administration taxes payable on that 50% real estate portion. Okay, so we talked in my, I guess you can say my Commons webinar, which is called Wills and Estates, which is an hour long. That's my, I guess you can say it's our firm's flagship webinar that we've done like 14 times. It's really over the years. It's a really basic webinar in that we mentioned that a $1 million estate will result in approximately $15,000 of taxes. So if you have an investment property of $1 million and 50% is $500,000, then we're looking at 50% of 15,000, which is $7,500. It's a sizable amount to pay taxes on. It's a sizable amount to pay taxes on. Okay, so that's just the way it is when something is co-owned. Okay, it forms part of the estate and gets taxes. Contrast it with a married couple situation. So it's highly likely that a married couple will own property, their home, as jointly owned owners, and as I mentioned, a law of survivorship will pass it to the surviving owner, and it does not form part of spouse A's estate, does not form part of spouse A's estate. And because it's not part of the estate, when the trustee goes to file the will belonging to spouse A with the estate office and proceeds to complete the probate application, in calculating the value of spouse A's estate, there's nothing entered for the marriage property, the home, because law of survivorship says that spouse A doesn't own it. After spouse A dies, spouse A doesn't own it, which means spouse A's estate doesn't own it. The estate does not own it. It does not pass according to the will. It does not pass according to the will. Okay, the survivor owns it under the law of survivorship, and it does not pass according to the will. Since it does not pass according to the will, the trustee does not calculate the value. There's no value to calculate for the home because there was never percentage ownership. That's just the way joint owned assets work, and therefore no taxes are paid on anything having to do with the jointly owned home. And this is a desirable outcome because often married couples will give estate to each other upon one of their death. I give everything to my spouse, and vice versa, and the joint and law of survivorship means that that the spouse A's estate doesn't have to pay taxes on that, and that's a desirable outcome. If the house is worth $1 million, then there's no taxes to be paid because it was jointly owned. Okay. I'm also going to briefly mention insurance policies. Okay. The law of survivorship also applies to insurance policies where the policy owner has named a beneficiary right in the policy. So when you go to your insurance broker and you purchase your insurance policy, you can tell the broker that you want to name beneficiaries in your policy. Okay, and if you have named beneficiaries, it's practically the same effect as having joint owners. The law of survivorship will pass the proceeds upon your death to the beneficiary without the proceeds forming part of the policy owner's estate. It will not form part of the policy owner's estate. If it does not form part of the estate, it does not get calculated on the probate application. If it does not get calculated on the probate application, there's no taxes calculated. Okay. So why doesn't everyone just, jointly own their assets with somebody else, especially loved ones? If you're going to name certain loved ones in your will anyways, then save the trouble of having to pay taxes on those items and keep more money in the estate and to give to your loved ones, right? And people do that. So in our firm, we do get a number of clients who approach us to add their children to the name of their home ownership deed or transfer in the capacity of joint tenants. So they've got the married couple, and then the kids go on, the adult kids go on. Okay, we get that, and this is done after any mortgage is paid off. It's done after the mortgage paid off, and I'll tell you why. Just briefly, is that when you have a mortgage, the borrower's name on the mortgage must match the homeowner's name. So if you're going to change the name of the homeowners by adding joint owners, you have to change the borrower's names on the mortgage, and you have to get your mortgage pretty much reapproved by the mortgage lender. And it's not always a straightforward process, or it might not always get done on favorable terms as when you had previously done it. So most clients will wait until their mortgage is paid off, okay, and then add their children on title. What are advantages and disadvantages? Advantages, well, you get to save probate fees, or the taxes. You save taxes because if the two parents pass away, then the surviving owner will be the children, and they get the law of survivorship means that they will own it. And in the probate application process for the parents, the trustee does not have to enter the value of the home or the tax or calculate the taxes, because the ownership of the home has passed by way of survivorship to the children. Simple, okay? And you can save, and homes continue to rise in value a lot often, okay? That's typically what has been happening lately, okay? So that's a good thing to save probate fees. What's a disadvantage? Well, when this family is owning it all together, if you're an owner, owners have equal control over the property. So if if the home were to be sold, if the mortgage were to be amended, everyone must consent, including the children, okay, who were like new incoming owners. They have a voice, okay? And so you give up control when you share your ownership. You can kind of get around this by, if the new owners, the children, they prepare a limited power of attorney assigning decision-making authority all to the parents. Decision-making authority all to the parents. Then, so when the parents want to sell the house, they don't need to involve the children, because the children have prepared a power of attorney, okay, appointing the parents to make the decisions. That's one way to do it, okay? And I want you to also be careful too. We have heard of some parents who might have multiple children, only adding one child because they think that child is responsible, or tradition, it's the eldest child, whatever. I would caution against that, because case law says that there is a presumption that when you do that, when child parent-child own something jointly, the presumption is that it's not a true joint ownership. It's not a true joint ownership, and that the parent only added the child for convenience purposes so that the child can help handle, going to the bank and getting things done, right? For bank accounts, that is, or for signing documents. It's a convenience. It's what's called a constructive trust. It's a trust on behalf of the original owner or parent, okay? And the problem or potential problem with this is that on the death of the parent, the law of survivorship says that the surviving owner, that one child out of the many, owns it all. It owns it all, okay? And that could be fine, but often in the will, the parent's intention is to share everything equally among all the children. This is what is a common scenario, right? That prevents conflict. So now you've got the surviving owner of that child owner on that property owning everything, and the will says to share everything. And what if that child doesn't share and just says like, well, I already have it, I rightfully own it because I'm a joint owner and it's mine now, and the will says to share it, and that child didn't share it. Well, and property tends to be one of the largest value items that is contained in a person's estate. Like, it's your biggest asset value. So, well, then what do the other children get? What's left over? Personal belongings. So then the remaining children could bring a challenge to say this was not a true joint ownership, so it shouldn't have passed by survivorship. In fact, case law says that it's a constructive trust. It was never a joint ownership. It was never a joint ownership. Let's, this child who was a joint owner should be removed, okay? And the probate taxes have to be recalculated now. We have to put the value of the home back on to the application, and there is a duty to amend your application when there is a discrepancy or a mistake, and everyone goes to court and pays a lot of fees just to get this issue sorted out, and there's a family conflict involved, and people are out of pocket, which is not a good thing. So I've put down as my last item, if you have multiple children, consider adding them all. If they are all owners, are not going to fight. Okay? And that's what joint ownership is about, and it's a very popular strategy for reducing probate fees. Great, so that concludes our webinar on this topic. Our website is landmarklaw.ca. It's a very resourceful website, landmarklaw.ca. We get asked what our prices are. So our cost calculator is contained on the left-hand side menu. Click cost calculator and you can get the starting rate for what it would cost to do your will. Okay. And we also have client kits found also on the left-hand side menu to get started on preparing your will, containing intake questionnaire, verification form, and retainer agreement. If you enjoyed our presentation, we would appreciate a 5-star Google review. Google Landmark Law, click write a review, or the direct link is there, g.page/landmarklawpc/review. Easiest, Google Landmark Law, click write a review. And during COVID-19, we are offering social distancing outdoor patio signings, okay, to prevent, any droplets from spreading anywhere. We have hand sanitizer, disinfectant wipes. The gates open. We'll have that open for you so you don't have to touch any surfaces to arrive. There are also other signing methods if you cannot attend in person: virtual, remote, and counterpart signing listed on our website. Okay. The most popular signing method is the outdoor patio. Then after the signing, everything is done. Okay, everything is done. There's no follow-up. Everything is done. you'll see the other examples on my website are more complex. Great, and thank you so much for attending our webinar. We'll see you in the next one. Like our Facebook page at facebook.com/landmarklawpc /landmarklawpc to watch